Hello, everyone. So here we are back, week 2, legal writing school. Today, I'm going to try to say less, goal number 1. And we're going to talk about what to do when you lose a summary judgment motion and you want to appeal it. How do you get there? How do you get to the Court of Appeals? What's the timeline? What's the process? And how do you begin to think about writing your brief? So with that, we're going to get started. I do want to see if I can just for a second, sorry, but I need to figure out how to send a link out. I would like to do that. I probably can't figure it out. And so this will just have to be posted somewhere, but let's see. I don't know. I will figure that out some other time. Okay, I'm not going to waste any more time here. Okay, so I have a video on this already on YouTube, but the reality is not changing. Things are not changing. I posted the video kind of, I don't know, look, see this thing? My sister loves this. She will stand next to me and just blow it. It's really annoying and funny. Okay, sorry, distracted. Things have not changed in the summary judgment department when it comes to California courts right now. Judges are so backed up. They have so many cases. They're not, there's just not enough judges. There's not enough people. There's not enough time to deal with all the issues that are going on in every single case. So that makes it very tempting for judges to say, I don't like this case. Probably this case will lose at trial. The plaintiff's going to lose at trial. And I don't want to waste my time on this case that is for sure going to lose, or is for sure, that's not super persuasive, and I don't like this attorney, or whatever is going on with the judge. I'm not saying judges are explicitly saying, who can I weed out? But that's what's happening. They are frustrated and overwhelmed, and it's easier to grant a summary judgment motion on a case that you think is not going to be a great case than it is to let that case move forward. From the judge's perspective, that gets it off the court's docket. They don't have to think about it anymore. And worst case scenario, the plaintiff will appeal. I guess I should clarify. I'm talking about defendants bringing a motion for summary judgment saying that plaintiff can't prove their case. And when the summary judgment motion is granted, that means the case is over for the plaintiff. And so that means that the only real option there is either plaintiff will just say, okay, I guess I lost and I'm going to move on with my life and not pursue this anymore. Or they're going to appeal and try to say that the court should not have granted that motion for summary judgment and should have let the case go to trial. Almost always that's the case. There's very few cases where summary judgment is really justified, but we could talk about that later. But my point is, okay. Oh, so I was talking about from the judge's perspective. From the judge's perspective, you get the case off your docket. Worst case scenario, the plaintiff is going to appeal the ruling, and that's got to work its way through the Court of Appeals system, which is also fairly backed up. And so that'll take a couple years. That gets it kicks the football down the road. Worst case scenario, the judge gets overturned. And while judges generally do not like to get overturned, that's a risk that a lot of them are kind of willing to take right now. So because it's not immediate, it's in the future, and who knows what's going to happen. So that's the reality. That's what's going on in judges' minds for the most part. So the result is that more summary judgments are being granted than ever. And I thought maybe once trials started happening again and cases got back underway after the COVID closures, I thought that might taper off a little bit, but it does not seem to be. I am still seeing more losses than I think are reasonable. And every time someone comes to me with a motion that they just lost and they want to appeal it, I look at it and I just can't believe my eyes. Like, I cannot believe how these are getting granted. And I have personally written some summary judgment oppositions in the past year or so that I thought were slam dunks that could not be granted, that do get granted. And so the reality is you never know what a judge is going to do, and you never know, like, what you think is important is not going to be important to a judge. Like, there's just no predicting it sometimes. So no matter how much experience you have, and no matter how much legal research you do and how well you know the law, sometimes you're just not ever, like, things are just going to be out of your control, or things are going to be happening that you don't know behind the scenes that are going to make a judge want to grant the motion and get rid of the case. So that's the reality. So what do we do about it? So say you just lost and you're devastated and you have to go tell your client, look, man, I'm sorry, I don't know what to tell you, but the court granted this and your case is over. Here's your options. Like I said, you can take the case and you could just say, all right, I guess it's over. We don't win. We always knew it would be kind of a hard case, but I thought we'd at least get a chance at trial. But I guess we can't. I guess it's over. Move on with our life. Done. You could do that. You could also appeal. But before you appeal, you have to first decide if you want to do a motion for a new trial, or a motion for reconsideration. There's two different kind of aspects to them. I'm going to go over it quickly, but these will be separate videos later. So I already talked last week about motions for new trial and how important they are for padding the record, for adding documents and information that the Court of Appeals might want to know that's not already on the record. So you do that in the form of your declaration, where you could attach certain things, or you can get other people to give you declarations in support of your motion for new trial. There's often not a reason to do this for summary judgment, but you totally can. And the worst thing that happens is the court says, no, I'm not going to reconsider this. I'm not going to give you another chance. It's over. So there are reasons to do it, but it's not always the best option, or a fruitful one, I guess. You could do a motion for reconsideration. Two quick things about a motion for reconsideration. One, I said again. I'm saying a lot. I will get better at this, I hope. Motion for reconsideration can be done. You've got to do it within 10 days of the ruling, so you have very little time. And to do it, you've got to have some sort of new evidence or new information that wasn't considered by the court. And you have to have a good reason for having not brought that up at the trial court level. But the trial court always has the inherent power to reconsider or change prior rulings in the case. So even if you don't have a good reason for not having brought it up in the first place, or even if you don't have anything new that the court should consider, you could still bring a motion for reconsideration and give the court another argument or some other reason to do it. Courts are not going to be happy if, like, this is a regular thing that you do. But if you feel strongly about something, the court does have the inherent power to reconsider and make a ruling on a previous motion. Now, if you're doing it under the CCP statute, which about reconsideration, there's those rules I told you about. It has to be new information that wasn't considered by the trial court, and there has to be a good reason for not having brought it up along with your original opposition. That's kind of a high burden to meet, but sometimes it happens. So if you get through that, you don't want to do a motion for new trial, or the motion for reconsideration is not granted, then you do the appeal. Oh, let me say this one more thing. And I probably now I'm just doing most of my motion for reconsideration video right now, but if you inadvertently left out evidence or failed to bring up a legal argument in your motion, in your opposition, still feel free to bring that up in a motion for reconsideration. The court may or may not consider it, but there is always the argument that there is always the chance that you could bring a 473 motion, which is basically like a mistake motion, like a, hey, I as an attorney made a mistake in failing to bring this up or in failing to do this. And now that mistake has resulted in a judgment against my client. And that's really unfair to my client. You, the client should not suffer for this mistake, inadvertence, or excusable neglect that I showed. And so then you've got to show the court like there's actual excusable neglect. It's not just like inexcusable neglect. But that's always a thing you can argue too, because then if that's really the case that you made a mistake or that you forgot to include something, you can, after the judgment is entered, you can do that 473 motion and have the case reinstated. It's a little bit technically tricky, and we'll have to talk about that some other time, but it's a possibility. Okay, so now we're at the appeals. So what you've got to do is you've got to file your notice of appeal within 60 days of the entry of the notice of entry of judgment. So a lot of times that's on the date that the court gives its ruling or within a few days afterwards. It's pretty quickly. So keep in mind, I usually just try to calendar like the date, 60 days from the date of the hearing, just to be safe. But you don't have to wait all the way till the 60th day. You can, as soon as you get the ruling, you can file your notice of appeal right away. The notice of appeal is easy. It's a 1-page, I think, judicial counsel form. It's literally like, judgment was entered on this date, and you check the box that says appeal after judgment from a motion for summary judgment that was granted. And then you sign it and you file it. Piece of cake. Within 10 days of that filing, you've got to file the notice of appeal at the trial court. You do not file it in the Court of Appeals. You file it at the trial court level. Once the trial court gets it, they're going to they have their own internal things that they do. Within 10 days of filing that notice of appeal, you have to file your notice of designating the record on appeal. I feel like I could do an entire video on the notice of designation of record, and I will someday. So that's another form that basically is like, here's all the documents that are on record at the court that I want to be in the appellate record. And here's the transcripts that I want to be part of the appellate record. And here's the exhibits that I want. Basically, here's everything that I want to go into the bucket of documents that the Court of Appeals will look at and consider in making a ruling on the appeal. Okay, you do that within 10 days. Once the court gets those two things, it's going to send a notice to the Court of Appeals, and it's going to tell the Court of Appeals to start getting things opened up. And the first thing you're going to have to do is, within 15 days of that case getting opened up at the Court of Appeals, you're going to have to file what's called a civil case information statement, and it's going to have the case information at the trial court level. So that case number, who the parties are, who their counsel are, all that stuff. What the underlying case was about. Was it a contract dispute, or was it an injury or medical malpractice, or was it like, what kind of case was it? And so it's going to tell you everything. And then you've got to attach the judgment to that civil case information statement. And then the judgment is reviewed by the Court of Appeals. And once the judgment exists, then once the court determines it's valid, the Court of Appeals will determine it's valid, and then they'll wait for the trial court to send them the record, and then they'll set the briefing schedule. Okay, so now you've got to start thinking about your brief. How do you write an appellate brief? The temptation is to just basically reiterate your arguments in your opposition to the motion for summary judgment, right? Because in a nutshell, like at a big picture level, yes, that's what you're doing. You're telling the Court of Appeals, here's what they argued, here's what we argued, here's what they did in their reply, here's what happened at oral argument, and the court got it all wrong. The court got this all confused, and you need to make it right, Court of Appeals. It's not as simple as that, but that's basically what it is. It's basically you're telling the Court of Appeals to change what the trial court did. And the standard of review when a court of appeals is reviewing what the trial court did, it's called de novo review, which means the appellate court is going to look at it with fresh eyes. They're not really going to consider or give deference to what the trial court ruled. And what that means is they're not assuming the trial court got it right. They're not assuming the trial court got it wrong either. They're just assuming that they're not making any assumptions. They're going in with fresh eyes. They're going to know that the court denied or granted the summary judgment, but they're not going to know the reasons or anything like that. And they're not going to give weight to that. Most appeals, the Court of Appeals is going to give weight to what the trial court did, because the trial court is in the best position to know things about the case and the parties that do not come across on the record, right? So most things, especially evidence-related rulings or at the trial court level, are considered for abuse of discretion. A court to be overturned really has to mess up. Their ruling has to be completely arbitrary or capricious or wild. And that doesn't happen very often. Even if you dislike it, or even if it is not in line with the law, like it's really got to be a blatant violation of the law. So it's difficult to win on appeal. There's the story, the phrase is an appellee, a person appealing, the appellant. Why can't I say the right word? The appellant is usually a two-time loser, because you lose at the trial court and it's really hard to get things overturned on appeal. The easiest type of appeal to win is when you have a de novo review situation, like a summary judgment motion. The Court of Appeals has to go in with fresh eyes and look at everything as if it's the only court that's ever looked at it before. They don't have to say, well, the trial court did it this way, and the trial court usually doesn't get this right. They don't have to say the trial court doesn't usually get this wrong, so we're going to trust what the trial court did. They have to look at it all fresh with new eyes themselves, as if they're seeing it for the first time, and they get to make rulings about the law, about what statements are, what factual issues there are, or disputes there are. They get to look at all that as if they're seeing it as if it's the first time any court has ever looked at it. And that's the best ground you could hope to be on in summary judgment. That's the best ground you can hope to be on in an appeal. So I say all that to say the temptation is to just literally put in your summary judgment opposition arguments and be done with it. But that's not what I like to do when I'm starting an appeal. Sure, those arguments are going to be there, but I like to take it from the perspective of what the trial court put in its ruling and where I can attack that ruling. There's a couple ways you can come at it. You start with anything you can get the transcript of the hearing is super important. Anytime the judge is talking, you're going to be able to find stuff in there that says that the judge was not considering the evidence, or that the judge was weighing the evidence. You want to get anything that shows that the judge weighed evidence is your ticket to a win from Appeal Town. The judges are not allowed to weigh evidence at a summary judgment. They're not allowed to say this witness is more credible, this document is more credible, this document is more important than this document. They're not allowed to weigh it and say what's more important or what's likely to happen at a jury trial. That's extremely forbidden. And if you can find any evidence of that in the language of the judge, the way that the judge speaks at the hearing, or the way that the judge writes in its minute order, anything that you could find that tells that gives that feel of weighing evidence, you want to highlight that. That's got to be your first issue. The judge weighed evidence, which is not allowed at summary judgment. The judge ignored statements of fact, disputes of fact. That's good. one of my favorites is if the judge brings up an issue that nobody argued, but that's not okay. If the judge on its own, his or her own, comes up with a rule and says, look, you guys are arguing back and forth about this thing, but like you guys are forgetting this thing over here that really makes this case impossible. And now I'm not letting this case move forward because I know about this thing, and you guys should have figured this out and talked about it in your briefing. You didn't, and too bad, but I'm granting this summary judgment based on this thing over here that you guys didn't even talk about. If you've got that, it's an automatic win, because the court, like there's the court is not allowed. It's called sua sponte on its own. Sua sponte. The court is not allowed sua sponte to come up with arguments that will help any side, but especially the side bringing summary judgment. Look, a summary judgment motion, if the defense wins, that's the end of the plaintiff's case, like I said, which means that the plaintiff is losing out on his or her constitutional right to have their claims heard by a jury of their peers. Summary judgment is a great tool for narrowing issues and like making sure we don't clog up the courts or waste the jurors' times on things that are not actual disputes. But when there's a dispute, that has to be decided by a jury. And that's the whole point of the jury system. And if you're just willing to quickly and easily throw away people's rights to bring their claims in front of a jury, that's an erosion of our Constitution. It's an erosion of constitutional rights, and it would be really bad for all of us. So allowing a judge to look at a case and say, maybe I don't like these facts, or I don't like this plaintiff, or I don't think that this is the type of case that should be brought. I think everybody needs to grow up and go home. Like, regardless of those thoughts, a court cannot make it easier or enable or enhance, or I don't know what the good words are, but to like facilitate the granting of a summary judgment. The court cannot make up something on summary judgment if the defendant didn't bring it up in their moving papers. So regardless of whether the court is completely right on the subject or not, say the court brings it up and says, this issue really nullifies plaintiff's chances of winning. It doesn't matter. They cannot grant summary judgment based on that, because, like I said, it takes away constitutional rights of the plaintiff, and it's really on the defense counsel or the defense to come up with that argument. If the defense doesn't do it, the court cannot help the defendant that way. So that's a great thing to look for in the court's ruling and in the court's comments during oral argument. If the court is not engaging in oral argument well, if the court is not listening or participating or asking questions of the plaintiff's counsel as it went during oral argument, those are things to bring up. Things that show the court did not actually consider the issues, that's really important. Those are all the things I want at the very top of my appellate brief. I also want it pointed out clearly what evidence the trial court considered, and if there were any evidentiary rulings. If there's rulings throwing out evidence, if there's rulings throwing out evidence, I need to know that right away, because those rulings about evidence, if you want the Court of Appeals to reconsider that or to determine whether those rulings were correct, that's a different standard of review. And that's a thing that's got to be argued separately from your arguments about what the court should have done. So I need that to be pretty clear right up front. I always love it when the court says, I'm not making any evidentiary rulings, like we're considering everything as part of this motion, because that gives the permission to the Court of Appeals to also consider all of the evidence that was presented in the trial court. And so once you've gone through what the court's ruling was and pulled out any issues that you could find with the way that the court made its ruling, then you move on to whether or not the court's conclusion was correct. And then that's when you're going to talk about where the disputes of fact are and why those disputes of fact matter as it applies to the law, whatever you're talking about in the summary judgment motion. And that's pretty much it. And then at the end, you do a write-up. You do a quick conclusion. And then, of course, the very last thing that you always write is the introduction. It's the very last thing you write. So that's kind of how I approach it. It's the most simple kind of summary judgment, or it's the most simple type of appeal to write, because the issues are very narrow and you're talking about one court ruling basically and one hearing. So you've only got one transcript to go through, and the evidence has already been combed through and it's there. It's the motion, the opposition, and the reply. It's a fairly small record, and it's the best standard of review grounds that you're going to get. When you get a de novo review, it's your best chance on appeal. So you may think that because the court granted summary judgment in favor of the defendants, and now your case, there's judgment entered against you as a plaintiff, you may think that you are sunk and that everything's over. But I really think it's important to try to appeal these for a few reasons. One, I think that the chances of winning on appeal are much higher than you would think, especially because of the standard of review, the de novo review. Like I said, so many summary judgments are getting granted that I feel should not be. So I think there is a lot of trial court error going on right now, and prejudice is just assumed. So normally on an appeal, you've got to prove error, like you got to prove that the trial court messed up, and that's only half of what you're proving. The other half of what you prove is that error made a material difference in the outcome of a case. So on trial, there might be like lots of little errors that the court made, but they're probably not prejudicial errors because the facts of the case are such that the same outcome probably would have happened regardless of whether the court made that error or not. So, but on an appeal from a motion for summary judgment, prejudice is a one sentence situation. The prejudice is that the plaintiff didn't get to take their case to trial. They didn't get to have their case heard by a jury of their peers. They didn't get to have their day in court, a constitutionally guaranteed day in court. They didn't get it. That's super prejudicial. So if the court made a mistake in its ruling on a summary judgment motion, prejudice is assumed, it's just there. So you're already on good grounds for appeals that way. But even if you're going to lose on appeal, I still think it's sort of important to go through the process and do it. One, you never know if you're going to win or not, and it's just there. But two, we cannot just roll over and take it when courts are doing things that are unfair to people. Maybe summary judgment was justified in a case, maybe it wasn't. But unless that's challenged, the courts are just going to think it's okay to keep granting these summary judgments, to keep pushing out cases that are on that cusp, are a little bit questionable. It's really important to not let courts feel like this is okay. It's also not good for our opposing counsels and opposing parties in these cases. Namely, I'm thinking a lot about insurance companies and corporations that are big defendants and governmental entities that are defendants. It's not okay for them to benefit and take advantage of these wins and to start feeling stronger and more confident in their arguments, and to think that plaintiffs are not going to push this and pursue this as hard as you possibly can. So rolling over and taking it may make sense in a case here and there. It may make sense for a plaintiff to want to say, okay, I'm done with it. I'm not spending any more time and energy on this. But it's really important for us as plaintiff attorneys, as people who are trying to advocate for the rights of people who deserve and are denied compensation by these Goliath kind of defendants. It's really important for us to keep pushing and to say, no, we're not going to take it. We're not just going to roll over. We're going to keep fighting. And we think the trial court got it wrong. So I'm about 30 minutes in. I want to try to keep these to about 30 minutes. So I'm going to stop now. But if you have questions, of course, you can call me. And you can go to my website, ghostbriefing.com, or bovlawgroup.com. Both links will be in the description of this video. And I'd love to hear from you. I'd love to talk to you more about it. And I am always wanting to talk about legal writing in general. So this was kind of an overview, not fully legal writing school. This was more like California appellate law and summary judgment law school. But next week, I'm going to talk specifically. I'm going to pull out a recent appellate brief that we wrote that was based on a summary judgment loss. And I'm going to get detailed about the specifics of that case and how we attacked it, and we'll see what happens. It's still going to be pending for a while. I think all the briefs are in, but we've got to, still do oral argument and wait for the Court of Appeals ruling. So that'll be a while coming, but I can at least kind of go over some specifics and talk to you about how we craft the brief from scratch. So, and the things we pay attention to. Actually, I've got a couple options. I don't know which case I'm going to do, but that's what we're going to talk about next time. And I'm going to probably try to do like a share screen situation where you can see some of the work that gets done and the work that we do. So thanks. Have a great day. And I will talk to you soon. I need a better sign off. Okay, bye.